Hi, I'm Jamie Machek with the Wisconsin Valley Library Service. This is our third and final recorded webinar for 2022 called Management and Retention of Library Records, presented by Shannon Schultz. We hope you enjoy the presentation.
Thank you for taking the time to learn about management and retention of public library records in Wisconsin. I'm Shannon Schultz, the Public Library Administration Consultant on the Library Services team at DPI. By the end of this session, you will be able to identify public records and non-records, determine who the owner of a record is, know how to properly retain your records, recognize a public records request and be able to handle that request appropriately, understand how to dispose of records properly, and know where to go for additional help. First, let's consider why public records matter. Public records laws are sometimes referred to as sunshine laws, so that people of our state are not in the dark about the workings of the government that represents them. According to settled law, the general presumption of our law is that all public records shall be open to the public. This presumption reflects the basic principle that the people must be informed about the workings of their government and that openness in government is essential to maintain the strength of our democratic society. The Public Records Law requires that every record is presumed to be available to the public, and access can only be denied in exceptional cases. Because these laws and principles, all government employees, including library staff, need to have a records management plan. Records management addresses the life cycle of records. The record's life cycle is the period of time that records are in the custody of the library and usually consists of these stages. We start when we create or receive a record. Next, we determine how long we must keep it, where we must put it, how we use and store it, and finally, how we dispose of it. Library staff need to know what a public record is because public records are property of your local government and the law requires you to keep them and make them available to the public. In general, a public record is anything, whether paper or electronic, that contains information about government business with only a few exceptions. Electronic public records include emails, videos, audio files, database content, instant messages, and texts. How can you tell if an item is a record? To find out, ask yourself these questions. Does it record a business activity, action, or event? Do you need it to prove a transaction did or did not occur? Do auditors require you to retain it? Could it be used to resolve a dispute in the future? Do you need it to identify who participated in an event or had knowledge of an event? Does it support facts you claim to be true? Has the person with direct knowledge of the facts retired or are they unavailable? Does it support what you do? Does it have business, legal, or historical value? Is it mandated by statute or regulation? Does it support financial obligations or legal claims? If the answer is yes to any of these questions, then the item is probably a record. Another step in understanding the management of public records is to determine the ownership of the record. The official records holder manages the official record because they created or received the record as part of their job responsibilities. Generally, responsibility falls on the creator, but an item may be a record for a recipient if the item was used to make business decisions. Let's use Public Library Director certification as an example. Per statutory requirements, library directors submit certification application materials to DPI, and we approve them and generate certificates. Both DPI and the applicants have identical documents, so who is the official record holder? As certificants, library directors could retain those documents for as long as they are useful, but DPI must meet the retention requirements for all director certification applications in our state. That would make the director's copy a record for as long as it is needed, and the DPI's original copies the official record for the full retention period. If you use a personal device for library business, a personal device may be a computer, cell phone, tablet, Kindle, iPad, smartwatch, or other connected device such as a cloud backup, flash drive, or external hard drive. Any communication used to communicate government business is a record, even if it is sent or received via a personal account. This means that you are responsible for the retention of any records existing in your personal accounts. Those records, and possibly the device itself, must be turned over in the case of a records request, and you must ensure any public records are properly retained if you transition to a new device or account. By far, the easiest way to avoid this is to not use personal devices for business purposes. Materials on your personal device that are purely personal property with no relation to library business are not public records and do not need to be retained. Because Wisconsin Public Library is established under Chapter 43 are local government entities, all library records must be kept for the minimum retention time identified in the library's records retention schedule. Generally, retention schedules are adopted by the library board and state how long records must be kept and how they must be disposed of. The records holder is responsible for determining the appropriate retention time, storage method, and disposition of each record in their possession. DPI recommends that all Wisconsin public library boards adopt the General Records Schedule for public libraries and public library systems by approving and submitting the notification of adoption form per the instructions on our website. I have provided the link on the Important Resources page. There are very good reasons to do this. First, the library is required by law to formally adopt a records retention schedule, which means if your library board does not adopt this one, then the library would need to create one for yourself. Second, if you adopt this general records schedule, you are no longer required to notify the Wisconsin Historical Society before disposing of records, which you are required by law to do if you create your own. Third, by adopting this one, you know that you are consistent with all other libraries in the state. And fourth, it will help you to know what records you have and what ones you don't have, which is very helpful during a records request. There are two ways you can find the General Records Schedule for public libraries: via the legal page on the DPI Public Libraries website, or by going directly to the Wisconsin Public Records Board website, where you will find it in the Local Unit General Records Schedules section. The first 2 pages of the PLGRS contain very useful information about your public records requirements and several important definitions. The records details themselves begin on page 3. So if we look at this section, you can see that the expiration, does not happen until 2027, so we should have this for some time with some minor revisions. You can also see that it's for use by all units of Wisconsin government at the state, county, and municipal level. So that's how we know that it is for all public libraries, library systems, and then us at the state library as well. The first part is the scope, and you can see that it goes into great detail about the statutes. So these are great links for you to be able to access the statutes and what the rules are in each different section. Here's the Public Records Board link as well, which I've already referenced. This introduction link to General Record Schedule is very useful in explaining how to use record schedules. You may want to refer back to that when you are not necessarily recollecting all of the things that I talked about today. Then we have historical records and notifications. That's an important piece of this as well. Records formats, personally identifiable information, and how to handle that, and those things are determined, and required by statute. Confidentiality of records, superseded record series, which we'll get into in a little bit, and some other definitions like that. We are going to be focusing for most of this next section on these superseded records and closed record series and revision history. So let's just get started in that. As I said, the records details start on page 3 right here, and this may look familiar to you. This is the very beginning of 3 very important sections, which you have to understand in order to confidently determine the retention times for your records. So in this first section, from page 3 until page 11, consists of library-specific records. They're bylaws, annual reports, donor files, patron incident reports, and so on. Because these records are unique to public libraries and systems, their minimum retentions and dispositions can be found right here in this section. We see columns including a series description, whether personally identifiable information is part of this type of record, the minimum retention time and disposal requirements, a definition of what an event entails in the retention, and any additional notes that could come in handy. So when considering the series description bylaws, for example, this very first one, they do not contain PII, so there is nothing confidential, and their minimum retention and disposition is event and destroy, where the event is when the old bylaws are superseded by a new revision. In other words, old copies of bylaws do not need to be retained after revisions are made and approved by the board, so they can be destroyed at that time. Now the second section, found on page 12, once I get there, contains closed series. These are items no longer considered to be records. For example, your library newsletters used to have a 3-year retention period, but the Public Records Board has since determined that newsletters are not library records, so their retention has been eliminated. So you can see a number of these types of items do not need to be kept. And here's library newsletters. That's what that creation plus 3 meant before, but since they are closed series, you know that they are no longer considered public library records, so they can be disposed of. The third section, beginning on page 14, is the revision history. This is the section that trips everyone up, and it is imperative that you understand how to use this section. The RDA numbers listed here are the old RDAs from the previous retention schedule for libraries. So unless you are updating your processes to conform to this new current GRS, those numbers do not matter. These in the second column do not matter. Just focus on how the revision history works. In this section, you will see the record series title and the revision made. In the case of general correspondence, which is located on this third row, you can see that it is superseded by ADM 10, which means that you would go to that record number to determine the retention and disposition for general correspondence. Let me make that clear. Superseded does not mean that you no longer have to retain these items. It means that you have to go to a different general record schedule to find them. But this document gives you all the information you need to do that. The link in the header up here takes you to the full list of record schedules referenced in this document. So let's just look at a few examples. First, we're going to start with meeting room use agreements. Where do you think that would be? Meeting rooms are pretty specific to libraries. Most other government entities don't necessarily have them. So let's start with the first section of the document. I apologize, I'll scroll up quickly. So we'll look through this and see if we can find meeting room use agreements. And looks like we're getting close. And here we are. RDA number 023 says Internet Equipment or Room Use Agreements. So the series description helps fill that in a little bit by saying that the patron agreements abide by the library's policies when using computer, internet, or equipment or rooms at the library. So that fits what we're looking for meeting room agreements. It does contain PII, and the retention is event and destroy confidential, where the event is when the meeting room is no longer in use or the end of the business day. But what happens if they violate the contract? Say someone is assessed a fine for violating the meeting room use agreement or breaks equipment. What is the retention then? Remember when you're reviewing this, that these are minimum retentions, and you may need to keep some records longer if you need them for your own purposes. The Public Records Law Compliance Guide, an excellent resource that I've shared in the Important Resources page, states that you must hold on to any item that has been subject to a records request or litigation for a minimum of 60 days after resolution of the situation. I think that would apply here because if you have unfinished business with that patron regarding the meeting room use, you would definitely want to hold on to that agreement until all of that was resolved and then some extra time. So now let's move on to board meeting minutes. Where do you think an item like that would be? Well, the first thing you should ask yourself is whether a record is library specific or if it is general. Because board meeting minutes are not specific to libraries and happen in many different government entities, they're probably found in the revision history. So let's go down to the end section, which is the revision history. And see if we can find meeting room use. And I'm going backwards. Okay, minutes and meeting materials. That would be the one. That's the closest match. So we see from looking at this that it is superseded by ADM 25. So that would allow us to come up here and we click on the header so that we may follow that link. And this is what I described, where you can see the different types of general record schedules here. ADM will be under administrative records. So we'll click on this. And it said ADM 25. I have unfortunate news for you. This was just revised and they changed the numbering system. So that's really unfortunate. You can see that the layout is very similar. And ADM 25, now you can see that these numbers run a little bit differently. So we would have to look at the previous RDA number. But the easy way to do that, it's pretty simple to find by scrolling down. It's right here. ADM 25 is boards, councils, or commissions, records associated with boards, councils, commissions, and such. And it includes things like meeting minutes and notes and agendas. So you can see it may include PII. It may include confidential information, but the minimum retention and disposition is the event plus 5 years and transfer to the Historical Society or UW archives. And the event is the date that the meeting or approval of the document. So knowing how boards operate the following month when they approve the previous meeting minutes, it would happen then. And then the 5 years would begin from that time. And then they would be disposed of appropriately if they contained any PII. So that is how you use the revision schedule. In sum, here are your steps when using the GRS for public libraries. Step 1 is to open the GRS. Second, you must determine whether the record is a library-specific record or a general record. Library-specific records are in the first section of the GRS. If your record is not there, then it is either not a record or it is a general record. If it is not a record, it will be found in the closed series section, and there is no retention requirement, so you can keep or dispose of it as you wish. If it is a general record, then you need to go to the revision history section and see which general retention schedule it belongs to. They will be obvious once you familiarize yourself with the different schedules. When you know which one you need, based on the letters in front of the record numbers, you go to that header, click the link, and find the PDF with the correct GRS. Then you just go to the record number and determine its retention time and disposition. Just like the library resources made available for the public, staff information must be organized and stored efficiently so that items can be located when they are needed with efficiency and certainty. Documents are available for use and decision-making. Open records requests can be handled efficiently and within an appropriate time frame, and unexpected requests can be resolved quickly. Moreover, library public records ensure statutory and regulatory compliance, support discovery and public records requests, support better decision-making, safeguard vital information, preserve organizational memory, reduce operating costs, minimize litigation risk, Improve effectiveness and productivity by retrieving information faster. Reduce redundancy, paperwork, and clutter. Promote transparency in government. And fulfill obligations to the public. Filing physical records regularly and consistently is as important of a job task as anything else. Electronic documents that need to be shared should be on a shared file server if possible, where they can be accessed in case of an unexpected absence. When a project is started, a committee convenes, or an assignment is made, it is advisable to designate the records holder and location on the shared file server. Electronic records in particular need to be named properly so that they can be found and managed according to the retention schedule. Following good records management practices can benefit the library in many ways, such as improving access to information, saving time, space, and money. If you choose to retain some records exclusively in electronic format, be aware that additional rules may apply. Such records must be kept in formats that are accessible, accurate, authentic, reliable, legible, and readable throughout the entire record lifecycle. Refer to Chapter 12 of the Administrative Code for additional requirements. Generally, major technology systems should meet these requirements. But if you transition from one system or device to another, it is your responsibility to ensure that your old records are retained properly. Be sure to check with your IT staff or supervisor before proceeding with any project to convert records from one format to another, including scanning paper documents into electronic format for retention in that format only. The Wisconsin Historical Society has developed best practices for both organizing and naming electronic records. An example of a simple file structure to organize records is shown here. This file structure uses retention schedules as a way to group like records together and can easily be adapted for use in email or in your map drives. You can find this and more information at the links provided here and on the Important Resources page. As you develop your file structure, think about which documents are personal notes, drafts, and other non-record reference materials. It may be useful to clearly label these items or even keep them in separate folders or envelopes solely for your own reference. Giving this some thought is important if you choose to mingle your personal notes and drafts with other documents that are public records. Remember, any notes or drafts that you make available for others or share with others may become public records. Even a sticky note may become part of a record that it is attached to if its purpose is to communicate important information to someone else. At some point in your career, you will probably be asked for access to a public record. This typically happens when your records are in the storage stage of the record's life cycle, so you will need to know how and where to locate them. A public records request is any request for government records. It does not require magic words or a precise format. It may be submitted by email, by letter, by phone, in person, or by any other method. The request may be written or verbal. It does not need to identify the requester or the purpose of the request. Not all requests you receive from the public are public records requests. You must know the difference between a general request and a public records request and then act accordingly. Library directors are the default records custodians for the library under Chapter 19 of the statutes, unless someone else at the library has been officially appointed this responsibility. And until now, we have talked about records responsibilities of all staff. This is where the responsibility of the director as records custodian diverges from the responsibility of records holders. Chapter 19, Section 35 states, it is the responsibility of the records custodian to locate all records in the agency that are responsive to the request, review and remove information that is confidential under the law, tell the requester what you are withholding, provide the requester with regular updates on the status of the request, and respond as soon as practicable and without delay. There are more responsibilities outlined in Chapter 19 and more digestibly in the Wisconsin Public Records Law Compliance Guide. So if you are a director, you may want to review this information further. I have included them on the Important Resources page for your convenience. The final stage of the life cycle of a record is the disposition of records. Non-records can be disposed of when they are no longer needed. Records, however, can only be disposed of when the retention schedule has not expired and there is not an update or revision in progress. The retention period specified in the schedule has been met for the record, and there are no pending audits, litigation, or open records requests. Records containing personally identifiable information must be both kept and destroyed securely. This could be either by password or lock and key, depending on the format, and items should be destroyed by shredding. Your adopted records retention schedule will tell you what you need to do with each record to dispose of it. Before we get to the Important Resources page, let's have a short quiz to reinforce what you have learned today. Question number 1. Which of the following meets the definition of a public record? A. Personal notes that you take in a meeting and do not share with anyone else. B. Junk mail brochure inviting you to a seminar. C. Email from your coworker asking a question regarding a particular project you are working on together. Or D. The dictionary you keep on your desk. The answer is C, an email from your coworker asking a question regarding a project you are working on together. Option A could be a record if the notes were shared with someone else to assist them with their work. Question number 2. If you have a public record, how long do you have to keep it? A, until you run out of room in your office. B, as long as required by the library's records retention schedule. C, forever. Or D, 6 years. The answer is B, as long as required by the library's records retention schedule. Question number 3. How soon does your agency have to respond to a public records request? A, within 5 days. B, immediately. C, once a staff member can get to it after completing all other responsibilities, or D, as soon as practicable and without delay? The answer is D, as soon as practicable and without delay. This time can vary depending on the scope and the complexity of the record's request. If it is more than a simple request, you should keep the requester updated on the status of their request. Question number 4. Must a person who wishes to submit a public records request put the request in writing? A, yes, B, no, or C, it depends? The answer is B, no. A records request can come in any form, and the requester does not need to share their identification or even a reason for requesting the record. And last, question number 5. Text messages and emails on your personal devices that discuss library business are public records. A, true, B, false, or C, it depends? The answer is A, true. Items that discuss library business are public records, regardless of the account or device used. Such items and devices may be subject to retrieval if a records request is made. If you require additional information, you may wish to consider these resources depending on the circumstances. Perhaps the single most valuable resource I can provide regarding public records and responding to requests would be the Public Records Law Compliance Guide. The Office of Open Government within the Department of Justice is the foremost authority on open meetings and public records, so they are an excellent resource as well. They have a helpline which is provided here. Also included are links to the Local Government Records section of the Wisconsin Historical Society website and to the statutes pertaining to public records. Chapter 16 pertains to the state and local records under the Department of Administration, and Chapter 19 pertains to the records as general duties of public officials and employees. Then, of course, we have 4330, which is about the protection of public library records and circumstances under which records may be released. You also have the DPI website and staff as resources, your amazing system staff, your municipality, and your municipal attorney. Please be sure to keep your system staff informed of any challenges or issues regarding records requests. It really helps your system to serve you better when they are made aware of such situations. And last, you are always welcome to contact me with questions about any of this content. Thank you for your time, and I hope you found this information helpful.
We hope you enjoyed the presentation. For the next 10 to 15 minutes, please think about and write down the following. What are 3 takeaways from this presentation? What are things that you can implement in the next 3 months? What challenges does your library face when it comes to record retention? What can be done to improve? And where could you lean for support?